Good afternoon on this fine Sunday afternoon. This is obviously not legal advice, uh, but please subscribe, share it, send it to your favorite pet, do something with it. Glad to have you with me and hope this is valuable and provides you some insight. Today I'm going to talk briefly about how arbitration is a profit center in a way for Tesla and how it gives them a competitive advantage over other car companies in a different way. So often Tesla and most big companies, there are often class actions that are filed involving shareholders or users of the product. In Tesla's position, a lot of those class actions involve full self-driving or related claims as to full self-driving. There are also sometimes employee claims. But there are class actions that have been attempted and are ongoing against Tesla related to full self-driving. Usually the allegation is you promised me complete and perfect, and the response is generally from Tesla, future performance is dependent upon software improvements, so that they didn't obviously represent that it was fully done and what would happen in the future. So that's usually the kind of where the parties break apart. So Tesla is in a unique position relative to other car companies because it has a direct contractual relationship with its buyers. There's no dealers. For example, obviously like Ford, for example, has dealers. So if you're a consumer, you go buy your product from the dealer and not from the manufacturer, which keeps you one step away from the consumer. And it's important because that direct relationship is very important, because in Tesla's contracts with buyers, generally there's a mandatory arbitration provision and a class action waiver. So in essence, when you buy a Tesla, and it depends on how closely you review the contract, but if you buy the Tesla, buried in there somewhere is probably a mandatory arbitration provision which says if you have any dispute with Tesla, that you need to bring the dispute for the American Arbitration Association and their rules, and that you also waive class action. And again, it's because of this dealer model, the non-dealer model, where there's a direct relationship between Tesla and the consumer, that it's permitted. And that kind of direct relationship in law is called privity of contract. And that, in essence, permits Tesla to enforce that arbitration provision. From a practical standpoint, because of the cost of initiating an arbitration, so if I'm a consumer and I want to initiate an arbitration, and because generally involving the car issues, the upside dollar amount is usually minor, and since class actions will be challenged, often people elect not to pursue claims. One recent FSD class action in Texas was dismissed. A workers' class action was dismissed also in Texas, and it was dismissed on the basis that there was a mandatory arbitration provision, and the court said you had to arbitrate your disputes. There's a current one involving FSD in California called, I think it's Matsko versus Tesla. I think it was filed in October of 2022, and it's likely that Tesla will contest that particular class action on the basis, again, that there is a mandatory provision that's been signed by the consumer that says they won't pursue a class action. So the effect is that not only is it the likelihood of claims being filed less, so less claims will be filed, but the likelihood of the awards will be smaller. So because they're arbitration by a single arbiter, it's likely that the numbers will be of a smaller nature. That's just kind of the practical nature is. So you're more likely to get a bigger number in court with a jury than you are in a private arbitration. That's just kind of the lay of the land. Separate from that, so that's kind of the practical side of it. And this part is definitely not legal advice. But if you're a buyer of a Tsla product, you can preserve your right to a jury trial and class action, and that's if your contract permits, by sending a letter to Tsla, certified or equivalent, less than 30 days after you buy the car or for the period your contract gives you, to opt out of the arbitration and class action provisions. I'm not telling you to do that, but it would probably be in a consumer's best interest to leave all of their options open. So that was not legal advice. That was just me talking out loud. Now going back to the arbitrations themselves, I think as I indicated, AAA, the American Arbitration Association, I believe does most of Tesla's arbitrations. And per their own statistics, from 2017 to 2022, there were about 21 total complaints that were handled by the AAA, the American Arbitration Association, which yielded total awards of $280,000. That's for a 5-year period. So that's not a lot. That's not a lot of claims. That's not a lot to pay out, because in Tesla's business model and in their projections, legal fees and legal costs are incorporated as the cost of doing business. And those particular costs, for the size and exposure that a company like Tsla could have, at least as to these claims, are very small. Just to point out in contrast, I believe in Ford, in one lawsuit regarding their entertainment system in 2019, paid out $17 million to owners. And obviously VW, in litigation relating to emissions, paid out $15 billion, billion with a B. So when you look at the relative numbers associated with how Tesla's legal department has operated, they're minuscule compared to other car companies. So it saved legal fees, saves money in payouts, and it gives them the direct sales model, again, just gives them a direct advantage. Ford is learning from Tsla, and in the financing agreements, they're now putting in arbitration and class action provisions in there. Of note, I believe in the third quarter of 2022, there was a resolution that was proposed by Tsla shareholders that garnered some support for loosening up arbitration provisions for employees. So you might see that in the future. I'm not going to tell you how to vote if that comes about, but just to let you know that it's been discussed in the future. One issue that's open-ended, and we'll see how it plays out, because there is some ongoing litigation which I will address at some future point in time, is whether a contractor, not an employee, is stuck to the same rules regarding an arbitration and class action waiver. I guess we'll wait and see, and that will be determined in the near future. Anyway, have a great Sunday, and hope this provided you some useful information about a competitive advantage that Tsla has, and also maybe a consumer reference that might protect you in the future.